Thank you, Marshall and Leonor, for inviting me. I appreciate it very much. This is my third visit to Brazil. I hope there will be many more. While I was en route here, it's a long flight, and I overheard a very long conversation between the two people in front of me in the plane. And one was, I say this as an object lesson for anyone who's making a speech immediately after a very practical panel, such as the one we just heard. This woman was talking at great length about her grandchildren and her children, all three children, where they went to school and how successful they were. And the other woman, the younger woman, just kept saying, "Oh, how interesting." And then it came all the 5 grandchildren and where they were going to school. How interesting. And the sports they were playing. How interesting. This went on for a long time. Finally, when she'd run out of children and grandchildren, she said, "Well, where did you go to school?" And the young woman said, "Well, I went to charm school." "Really? What do they teach you in charm school?" "Well, they teach you to say, 'how interesting,' instead of 'who gives a damn?'" So, I hope we don't repeat that situation this afternoon. As Marshall said, I'm here to talk to you a bit about specialized competition courts as an idea, and its possible for practicality here in Brazil. My understanding is that the judicial regional courts are now looking at options for how this might be undertaken. I'm not sure whether they're expected to be favorable or unfavorable, but there will be some sort of recommendations, I imagine, coming fairly soon. Of course, Brazil would not be the first country, if this is done, to implement specialized competition courts. Others have done this, including the United Kingdom, Canada, Chile, and until very recently, India. There are also a number of examples of other types of specialized courts around the world. And in the US, we have, in a related field, we have the Federal Circuit, which handles patent cases, patent and tax cases, but for our purposes, the interest is in patent cases. And there's a trend toward this increasing use of specialized courts, as I say, around the world. But the whole subject remains one of debate, not just in Brazil, but wherever this is being considered. So I want to give an overview first of some of the benefits and downsides of specialized courts more generally that have been documented in the literature, so I won't dwell on them very long, synopsizing what I think is known now, and then explore these benefits and downsides and see how would they likely play out if implemented, if a court of such a nature were implemented in Brazil. And a great deal, this is really the take-home, a great deal depends upon the way in which the court is structured. So I will give some thoughts on the key design considerations for a specialized competition court. The objective being, of course, to avoid the potential problems with specialized courts and still being able to capture the advantages. So at the outset, I want to clarify what I mean by specialization. First, there are at least 2 possible dimensions to specialization. One is measured by the share of the judge or the court's docket devoted to, in this instance, competition matters. And second, the degree of antitrust expertise among the judges when they're first appointed. And an antitrust court, competition court, could employ either or both of these forms of specialization, choice likely to affect the resulting benefits and costs. And there's also informal, as opposed to formal mechanisms of specialization. There's so-called opinion specialization, in which a particular judge or judges on a generalist court tend to write the opinions in that particular subject area because of their prior experience or because of their interest in doing so. And in this way, even a generalist court can realize some of the advantages of specialization. Now, I understand that one of the main reasons that a specialized competition court has not been created already in Brazil is that it was thought that the regional court for Brasilia would be the place where most cases were filed, and it would in time become particularly skilled in economic matters. On the formal side, formal end of that spectrum for specialized competition courts is the United Kingdom's Competition Appeals Tribunal, or CAT, C-A-T. It was created in 2002, and the CAT is a distinct tribunal with exclusive jurisdiction over appeals of administrative decisions previously coming from OFT, now from the CMA, the Competition and Markets Authority, as well as private claims for damages or injunctions. And the point I want to emphasize here is that how this specialization, as I've said, it can be achieved in different ways. The benefits that we're looking for are efficiency, uniformity, and expertise. So I'm going to start with efficiency, defined in terms, to make it simple, but I think it's as good as any, as the rate of judicial output. That is the time it takes to dispose of cases within the specialized jurisdiction. This seems to be an intuitive idea that judges with greater experience or expertise are going to be able to dispose of cases more readily, more quickly than generalist judges who have to get up to speed with every new issue that they encounter. In the US, we have about 800 first instance federal judges. And most of the judges will never hear more than one competition case in their career. Those in San Francisco and New York and Chicago will hear many, or at least their court will. Most of the individual judges will hear several. But for the judge sitting in a smaller jurisdiction, it will be a one-off event, if that. So we can expect that we would find more expert results in those jurisdictions where the cases are common. The idea here is that with experience, a judge becomes familiar with the regulatory scheme overall, in this case competition, and sees more quickly how a case fits into the relevant statutory framework or in a common law system into the body of precedent. And consequently, the judge comes to see quickly whether, for instance, whether a new case presents a serious issue or one that can be disposed of rather readily on the basis of what the code says or prior case law, and one that, so there's no need to go back and read cases and commentary and provisions that the judge has studied before. Furthermore, Judge Gerald Barling, who was previously the chairman of the presiding judge of the UK CAT, pointed out that a specialized competition court can tailor its procedures for the types of cases that it hears. And the example he gave of merger cases, some merger cases, not all, but some merger cases are really extremely urgent. And the CAT endeavors to resolve those cases within a matter of a few weeks. But identifying which ones are urgent and which ones are simply you're told by the lawyers are urgent may be a very different matter and requires a good deal of experience to know what you're doing. The efficiency benefits to a specialized competitive court can be particularly great because economic evidence and expert testimony plays an integral role in nearly all competition disputes these days. Additionally, delays in resolving antitrust cases can be especially harmful due to the effect on the marketplace. Parties to a merger cannot keep it together for years while appeals go on. They have to run their businesses. And I think most jurisdictions are sensitive to that. But if the general judicial system is one that takes years and years in which to resolve cases or can be prolonged by parties who continue to appeal, then that becomes impossible. Those transactions become simply impossible to consummate. And my understanding is that efficiency gains are a major goal for the idea of having a specialized court in Brazil, as opposed to, because of the delays being so substantial now in the general courts. The evidence supporting this hypothesis, unfortunately, is rather limited. Professors Kazin and Gwendolyn Ball, found that specialized patent experience shortens the duration of patent disputes, but when the judges have that specialized experience, only to a moderate degree. We would hope that it would be a greater degree in competition cases. Then we turn to uniformity, the second virtue that we would want to achieve. This is foremost the elimination of what in the US are called circuit splits, in which there's a conflict between the views of two different courts on the same issue, by giving a specialized court a monopoly over decisions in that subject area. So this is exclusive jurisdiction, eliminates the problem of different courts issuing competing and conflicting rulings, not in the same case, but in different cases. In addition, even if a single specialized court has multiple judges or different chambers, it is more likely to render decisions that over time create a coherent body of jurisprudence than would judges of completely separated generalist courts. Now, of course, imposing such a monopoly is much more practical at the appellate level than it is in the trial court or first instance level in most countries, because there are too many cases for a single trial judge to handle them all. So you're going to have multiple first instance judges if that's the case, but that needn't be the case on appeal. I'll get to that in a moment. So this point about uniformity increases predictability for potential litigants and their counsel, and of course eliminates the possibility of forum shopping, of going to the court that is thought to be most likely to be favorable to your cause. But there are people commentators on the subject who doubt that a specialized tribunal would produce any greater uniformity over time. In the US, in particular, Judge Richard Posner, who's written so much about economic analysis of law, has argued that inconsistencies in the outcomes of antitrust cases over time will reflect deep philosophical disagreements that cannot be eliminated by committing all the cases to a single specialized court. So he wrote, and I'll quote him here, "The appearance of uniform policy that would result from domination of the specialized court by one of the contending factions in antitrust policy would be an illusion. It would reflect power rather than consensus. A turn of the political wheel would bring another of the warring camps into temporary command. There would be a rapid vacillation between extremes." Now, that may be a rather jaundiced view, beyond just skeptical, but of course he's referring to persistent divisions over time in the US and several other jurisdictions, philosophical divisions about the role of competition law and how intrusive it should be, how ready to intervene, and the degree to which it can veer over into industrial policy, as was mentioned in the previous panel. Let me turn now to expertise, by which I refer here to technical facility, as distinguished from a substantive shift in the law in one policy direction or another. Due to the economic complexity of competition cases, generalist judges may lack an accurate understanding of the specialized legal terminology and the economic concepts that are so typically used in our common field. Specialized judges can develop a better understanding of these things, resulting in decisions that are more clear and logical. Not too many years, perhaps 20 years ago, the ABA section, American Bar Association section of antitrust law, polled testifying expert economists on how well they thought the court understood their testimony. The number who thought the court understood their testimony without great qualification was 24%. Now, maybe that's because they lost their cases, so they figure the court didn't understand what they were saying. But whatever the case, the economists were not confident that they were getting through to the generalist judges. Specialized courts can also be in a better position to understand when it's preferable to sacrifice accuracy in a given case or even a given doctrine in favor of easy administration or a bright line rule, compared with situations where accuracy is paramount. Ordinarily, in jurisprudence, we do seek accuracy in every judgment. But when we're dealing with the recurring issues that arise in economics, and one has to choose between one rule and another rule, it's hard to argue that ease of administration should not be taken into account. There's some empirical evidence that judges struggle with antitrust cases involving sophisticated economic evidence. Professors Michael Bay at Indiana, former chief economist at the FTC, and Josh Wright, my colleague at George Mason, examined U.S. antitrust cases, and they found that the decisions involving some evaluation of economic or econometric evidence were appealed approximately 10% more frequently than cases that demanded less economic skill. And maybe more important, they found that the decisions of the judges who had attended a brief training program to learn some basic economic skills, their decisions were appealed about 10% less often than those of other judges. So training did have an effect, although somewhat modest, certainly not to be ignored. Now, some scholars have expressed skepticism that specialized courts can solve the problem of a lack of expertise amongst generalist judges. To the extent that a competition court is still subject to review by a higher generalist court, so let's say by the Brazilian High Court, the Superior Tribunal, the malfunction may simply be to move the misunderstanding up a level from the expert judges who understood it to the non-expert judges who then mangled it. Danny Sokol, who's going to be speaking at this conference later on, from the University of Florida, he believes that that's what's occurred in Chile, that the Chilean Supreme Court has repeatedly overturned decisions of the Tribunal de Defensa de la Libre Competencia, the specialized court, quoting Danny, despite the validity of the TDLC's economic analysis. And he argues that this trend has chilled the agency in its own decision-making and discouraging it from faithfully applying economic principles to the law. And this is one possible interpretation of what's happened in the U.S. with the Federal Circuit, our specialized court of patent appeals. The U.S. Supreme Court, generalist of course, has struck down several significant patent doctrines that were crafted by the specialized court over a period of years. There are some similarly familiar objections to specialized courts. I'm going to distill them into 6 categories. And the first is the loss of independence, which can occur in 3 ways. The first being selection bias. That is the danger that the judges selected to serve on the specialized court are systematically biased in one direction or another. 2 reasons for which this might arise are, first, that interested groups, including, of course, the National Competition Agency, might have a greater incentive to try to influence the selection of generalist judges, of specialized judges, than they would if we were talking about generalist judges. The need for access to political officials inevitably gives advantage to the agency as an arm of the government. To the extent that courts reviewing administrative decisions already indulge the government with a lenient standard of review or place the burden of persuasion on the regulated party, any additional bias in favor of the agency would deprive the public of a meaningful check on the agency. Second, the pool of potential judges may itself be biased. Judge Rakoff, a well-known judge in New York Federal District Court, gives the Federal Circuit, our patent court, as an example of this. In his view, because the Federal Circuit is largely staffed by judges drawn from the patent bar rather than from antitrust backgrounds, the design of the court virtually guaranteed that it would produce pro-patent case law at the expense of competition concerns. Now, how, you might ask, do competition concerns arise in the specialized patent court? And one frequent example is that there's a patent infringement case brought, and then the defendant counterclaims with a competition claim. Okay? So claiming that the patent holder violated the competition laws in some respect. The inverse problem could plague a competition court, where the candidate pool is likely to be populated by lawyers who elevate competition concerns above other values, such as those animating intellectual property or contract law, for that matter. Now I turn to capture. Not bias, selection bias at the outset, but capture. Once appointed, a specialist judge may be more susceptible to capture than a generalist. To begin with, he or she is going to be subject to the continuing influence of the repeat players. Obviously, the most repeat player will be the agency, in this case, CAGE, and maybe in a few major law firms as well. The repeat players are highly experienced, sophisticated experts in their own right, and repeated interactions could, over time, result in a judge developing an undue trust in or bias in favor of the enforcement agency. And for that reason, interest groups anticipating this risk might well vigorously oppose the creation of a specialized competition court. In addition, judges in specialized courts are typically appointed for a term of years, after which they return to the private sector. And this is true in the other courts I've mentioned around the world. But even if they have life tenure, there has been a growing tendency for judges, at least in the US and a few other jurisdictions, to leave the bench before they retire, and of course, then to go back into the practice of law. That's prohibited in some places. In the UK in particular, a judge who has retired or resigned cannot appear again in court. But that's a rather strict and I think unique rule. The inevitability of going or returning to the specialized practice after serving on the bench may well affect the specialist judge's perspective and consequently his or her views on substantive legal issues while still on the court. Capture might be particularly problematic in the Brazilian system because the CAGE has greater power than many antitrust agencies around the world, including those in the US. In the US, the Federal Trade Commission and the Antitrust Division of the Department of Justice do not have the authority to block a merger themselves, for instance. They have to obtain a judicial order. And the CAGE, by contrast, acts as both the investigator and the decision maker, so that a lack of meaningful judicial review would leave an already powerful agency unchecked. I think there are solutions to all of these problems, by the way. Don't despair. Third, specialization may amplify the role of ideology. Now, the theory here is that in a subject like competition, where there may be clear policy differences and even factions, specialists will be more likely than generalists to possess or at least to develop strong policy preferences. Indeed, one study has found that appellate judges who specialize in antitrust are significantly more likely than non-specialists to vote in ideologically consistent ways, either for the government or against the government, but more consistent than non-specialists. So specialization seems to amplify the effect of ideology on decision-making, and therefore to increase polarization on the bench. Tunnel vision. A number of commentators, especially those who are themselves generalist judges, worry that specialist judges will develop tunnel vision due to a lack of contact with other areas of the law. Generalists, by definition, have a breadth of experience on which to draw. And some observers think that such cross-pollination, if you will, is an important ingredient for effective judicial decision-making. Exposure to other areas of the law may be, in fact, may give the generalist insight that are unavailable to a specialist, but are nonetheless helpful in a broader context, perhaps one that implicates limitations on government institutions. It also ensures that judges consider the implications of their decisions in any particular area on other areas of the law where similar concepts arise. Oh, thank you very much. So you might think about something like negligence, which might arise in torts, but also arise in company law with respect to the duties of directors. And so saying something about negligence in one sphere may spill over and affect decisions in another sphere, and a generalist is more likely to temper their decisions because of an appreciation of those implications. Another, and now I'm at the third of these six, another possibility is that specialization will cause judges to develop and to rely on jargon instead of having to explain the issues and their ideas in plain terms. A very distinguished U.S. judge put this matter as follows, and this was several decades ago, mid-20th century. It is not wise to create a small group of men who become, like the Egyptian priests, the sole custodians of a body of knowledge, and who sooner or later begin to talk a language that nobody else understands, but which is common only to them and the practitioners who appear before them, and who drift away from those general principles of equity and morality which pervade the entire judicial system. A thought that goes back a long way and probably will be with us for a long time as a concern. All right. Fourth, research does suggest that because of their expertise, some specialized courts get more deference from the generalist courts that review their decisions. Okay. Now, I mentioned that our Supreme Court has had no hesitation about overturning patent decisions from the Federal Circuit, but that's not true with respect to tax decisions. With respect to tax decisions, the reviewing courts, both the circuit courts at my level and the Supreme Court, seem to be very deferential to the tax authorities. It's a difficult field of study, a dangerous one for the non-specialist to step in, and it's safe to rely on the government. That's what it comes down to. In fact, the English Court of Appeals has said about the CAT, about the Competition Appeals Tribunal, quote, "The conclusion of an expert and specialist tribunal specifically constituted to make judgments in an area in which judges have no expertise is in an area in which this court would be very slow to interfere." So the generalist court reviewing the specialist would be very slow to interfere. And it's in a competition context. And that deference just may be too much. So we have evidence on both sides of this issue. I'm going to turn to the fifth, the monopoly problem. If the specialized court has a monopoly, and it almost surely has to have, then we may encounter all the usual problems created by a lack of competition with which we are all familiar. Specifically, one can see the argument that an ongoing lively jurisprudential debate across courts is necessary to check biases and poor decisions. It also tees up cases for the court of last resort by facilitating the development of varied views, so that indeed our Supreme Court not uncommonly will deny review, it has discretion, deny review of a case in which there's a split between two circuits. The apparent theory being by the Supreme Court, let's wait and see what the other circuits do. Get some more views on this, see how the issue evolves and matures. And of course, that possibility is foreclosed if there's a monopoly court for that subject area. So one might say that after all, innovation in law, as in technology, is a result in part of competition and experimentation. All right, administrative challenges associated with specialized courts. Finally, there are boundary problems. I mentioned the one in which we have a competition counterclaim in a patent case. What are we to do? Send it to the patent court? Send it to the competition court? Throw up our hands and send it to the generalist court because it has both fields involved? And this is a very common overlap. Caseload management. Now, to recur to Judge Posner, he's objected that the caseload of any specialized court is going to be more volatile than that of a general court, making it more difficult to match the supply and demand of judicial resources, supply of and demand for judicial resources. And in Brazil specifically, I understand that one main reason that specialized competition courts have not yet been created is also the small number of lawsuits in this field. And I think there's a solution to that. Now turn to attracting talent. So a couple of commenters here have emphasized the potential difficulty of attracting highly qualified individuals to serve on specialized courts. To put the argument crudely, it's that specialized judgeships may be less prestigious and less appealing and powerful because the jurisdiction is only in a limited area, one that you and I love, but not necessarily the one that most appeal to a potential judge. And there is, I'm happy to say, no real evidence to support this concern. It's not clear that the Federal Circuit, for instance, has been unable to attract the most qualified patent lawyers to become judges there. All right, so I've surveyed all of the basic arguments for and against specialized courts. I'm going to turn now to the particular situation at hand and explore the costs and benefits of specialization as they might be obtained in Brazil. Now, you all have a civil law tradition. And outside the field of competition, specialization is actually more common in civil law countries than in common law countries. Throughout Europe, we find labor courts, administrative law courts, a variety of specialized courts of that nature. Now business courts also arising in several countries in the EU. There are reasons to believe, I think, that civil law systems are actually better suited to greater specialization than our common law systems. Recall that one of the major costs of specialization is this tunnel vision and the resulting lack of cross-pollination. Okay, that was an objection. In a civil law system, however, you employ a comprehensive, periodically updated code instead of relying on judge-made common law. And because the code, theoretically at least, provides all the answers for any given issues, there's less to be gained from cross-pollination. What you want to know is, what does the code have to say? And increasingly, I would suggest, what does the codes have to say and what have we said before ourselves? Precedent, at least in the EU, precedent is very much more taken into account, I think, in competition cases than in other areas. And the code writers have presumably accounted for any connections or conflicts across different legal regimes. So recall Judge Posner's doubts about the ability of a specialized court to achieve uniformity and predictability in the law because of variations over time in the political, as the political regime changes, not political here in a very broad sense. Well, that's unlikely to be a problem in a civil law system because judges don't affect the substantive law to as great an extent as they do in a common law system. Furthermore, because the civil code is quite detailed, it tends to be quite complex And having specialized judges who are well-versed in the intricacies of that particular part of the code could produce significant gains in both efficiency and expertise. On the other hand, even in a civil law system, competition law does tend to be open-ended to the extent that it incorporates economic concepts and terms that have to be applied to a myriad of different factual circumstances. So these laws require significant commentary or case law to supplement the code, not so different from a common law system, in fact. So the cross-pollination, usually lost through specialization, may actually continue to inform a competition specialized court in a civil law country. And I would add that to a degree there is a global competition community that consists of the national competition agencies, the elite bar, and the scholars in this field. And we meet. We meet in Campos de Jordão, we meet in Brussels, we meet in Washington, and we see each other, and we exchange ideas, and we read each other's articles. So I think the prospects for tunnel vision are actually rather limited in this field. Looking at the mechanism for selecting judges, Brazil's model is more akin to a career judiciary than a recognition judiciary. In the U.S., Anglo-American common law systems, the prototypical judiciary is a recognition one in which the appointment of judges comes after an initial career at the bar, and usually involves another branch of government, not just the judiciary. So either the executive making appointments or nominating appointees to be confirmed by the legislature. By contrast here, as I understand it, the judicial selection for the courts of first instance is administered entirely by the judiciary, with no participation from the political branches. And candidates take entrance examinations and are hired for entry-level positions on that basis. Appellate court judgeships, in turn, are filled mostly by first instance judges, and the appellate courts themselves select 80% of the judges for promotion. The others being reserved, as I understand it, for the Bar Association and the public prosecution. So these organizations nominate a short list, and the president selects from that list. Structurally, therefore, the appointment of Brazilian judges is mostly insulated from political activism. And Brazil doesn't have a stable two-party system in which we have these people constantly alternating in power and different views on competition coming in with each new administration, including into the administration of the competition authorities. All of which means, I think, that Brazil has less risk of selection bias or ideological entrenchment under its judicial selection mechanism than we have in the U.S. Which leads me to a second and even, I think, more important point. It's impossible conclusively to evaluate the Brazilian proposal or concept at this nascent stage, because the particular structure and implementation of the specialized competition court is going to determine the extent to which Brazil is able to gain the benefits and avoid the drawbacks associated with specialized court. And I submit that it is possible to eliminate most, if not all, of the downsides by proper institutional design. So I'll spend the last few moments here of my time discussing design considerations. And my view is that antitrust courts should be staffed by judges drawn from the generalist courts, drawn for a limited time and only to the extent necessary based on the number of competition cases that have to be adjudicated. The selection of the judges should be conducted by the Brazilian judiciary, perhaps in the same way that the trial court judges are chosen for service on the generalist regional appellate courts. This setup has been used in other countries and for other subject areas. For example, the U.S. Foreign Intelligence Surveillance Court and its associated court of review are staffed in this way. The Chief Justice of the United States appoints 11 judges from around the country, 3 of whom must live in the capital area because they have to be convened sometimes on very short notice, and no judge can be reappointed. They spend the majority of their time on their generalist courts, either a first instance or a review, and they sit on the specialized intelligence court only as needed. The CAT in the United Kingdom is another example of this structure. The CAT is composed of both judges and laypersons. And I'll say more about the use of laypersons in a moment. But for now, I want to highlight the judges on the CAT. They are known as the chairman, and they preside. They are generalist judges that are drawn from the High Court of England and Wales, as well as equivalent courts in Scotland and Northern Ireland. This is a group of generalist judges that are on the list. Whenever an appellate case needs to be heard, a panel is convened with one of those generalist judges presiding. The others' positions may be filled by other judges or by laypersons who have been approved from a field that's relevant to the case at hand. It could be in accounting, finance, even business, economics, perhaps other fields as well. So we're getting there a generalist judge who is acquiring specialized experience and lay people who bring expertise to bear and have an equal vote, by the way. But you can put aside the lay people. That's maybe a bridge too far, okay? It would still be possible to imitate this structure that I'm describing, where the CAT is convened as needed and is composed of generalist judges who serve for a period of years in this capacity. So under this device, this selection system, the problem of selection bias entirely disappears. Judges would be continued to be selected for their qualifications as generalists, and the slight chance that a particular prospective judge might in the future be brought into service on the specialized court would be insufficient reason for anyone to expend resources furthering or retarding the appointment of that person. Similarly, the structure reduces the risk of capture. During the time of the judge's incumbency on the specialized court, there would be whatever efforts there might be to capture the judge by the casier, by the organized bar, to ingratiate themselves. They make you drink cheap wine when they come to your meetings. The limited term of special service and the certainty of returning full-time to their home court of general jurisdiction would mitigate the judge's susceptibility to influence in the number of years that they're on the specialized court. Of course, the competition court would still experience consistent exposure to the repeat players. And returning to the example in the US of the surveillance intelligence court, there are many people who worry that it gives too much deference to the Department of Justice, which is involved in every case before it. And we can similarly expect many of the cases before a specialized competition court to be enforcement actions, primarily actions brought by casier rather than private actions, although I hope there will be increasing numbers of private actions. But this is a risk that the competition court there is a risk that will too readily approve of casier's decisions, but I think it's much mitigated by the structure of having generalist judges coming in for a term of years. It affords ample flexibility to deal with the potential volatility of the special court's needs because it's convened whenever it's needed and it doesn't exist when it is not needed. Much like the electoral courts in many countries in South America that are called into service only during the periods of election. The judiciary can simply appoint more judges if the competition docket grows, take more of the generalists and assign them to periods if they're needed in competition. This greatly reduces their developing any kind of tunnel vision or concern about that would be, I think, completely eliminated. And the consistent rotation of judges on and off the competition courts would prevent the court from becoming insulated or technocratic, speaking in jargon and so on. Now, there are challenges that will remain. The boundary problems will remain. The monopoly problem will remain. The problem of undue deference will still be there to some mitigated degree. Selecting the right term, the length of term involves a trade-off. A term needs to be long enough, term of service on the specialized court needs to be long enough for the judges to develop sufficient experience to reap the benefits of specialization. But not so long that the judges become jargon-bound, with tunnel vision or bias or all of the other problems associated with deep specialization. My guess is that 7 years is about right. On the United Kingdom's CAT, members may not serve for more than 8 years. They serve at the pleasure of the presiding judge. So as I said at the outset, in conclusion, I can't give you a final opinion on the proposal for a specialized competition court in Brazil, but what I can say is that when it comes to the benefits and costs of specialization, God is in the details. I think there's a great potential for this new competition court if it's thoughtfully structured. And I hope I've given you some ideas to think about as you move forward to discussing this and shaping a proposal and perhaps creating such a court. I hope so. Thank you for your attention.
Muito obrigado, Judge, pela brilhante exposição, muito completa, abordou e acho que antecipou todas as perguntas que nós poderíamos ter. Mesmo assim, if you allow, obrigado. If you allow, would like to open for questions.
Yes, of course.
Okay.
You know, both as a judge and as a professor, I'm used to asking the questions. So it's refreshing to be asked the questions.
Muito bom. Inicialmente, eu queria passar a palavra ao diretor Bruno Drago, para ele falar um pouco da contribuição que o BRAC fez para o Judiciário sobre essa questão das varas especializadas e, eventualmente, fazer alguma pergunta para o Judge Ginsburg.
Obrigado, Márcio. Judge Ginsburg, queria dizer que é uma honra e um prazer tê-lo aqui. Quisera ter tido a oportunidade de conversar com o senhor antes até das interações todas que nós tivemos lá com o TRF3, mas certamente eu acho que, em vários aspectos, o senhor nos abriu a cabeça aqui com relação, principalmente, ao desenho dessas cortes especializadas e muitas das questões que nós temos aqui para nós como desafios. Eu tinha muitas dúvidas antes, muitas perguntas que eu queria fazer, mas eu acho que isso caberia num debate de dia inteiro, se nós formos discutir detalhe a detalhe e, como o senhor disse aí...
I'll be here.
Okay. Mas eu queria, antes até de fazer uma pergunta, rapidamente dizer como é que foi nossa interação. Eu, pela parte do departamento do Comitê de Contencioso Econômico, e o Francisco Negrão, na parte do Comitê de Comércio Internacional, conduzimos aí alguns debates com o TRF3, que é quem está na frente nessa discussão da criação de varas especializadas, seguindo ali a resolução 445 do Conselho de Justiça Federal, né, que aprovou aí a recomendação de especialização de varas. E aí, na sequência, veio essa portaria do Tribunal de Justiça, que criou um grupo de trabalho para debater internamente e com quem tivesse interesse em debater e formular aí um desenho dessa especialização dessas cortes e submeter isso, como de fato hoje está, na presidência do TRF3. Então, já há alguns meses está lá. Não há um claro timeline de quando é que isso vai ser decidido internamente, isso segue para um conselho no próprio TRF3, mas é provável que aí no próximo ano a gente tenha novidades com relação à criação dessas varas. Esse é um debate interessante em todos os aspectos, não só da revisitação das decisões do CAD, mas também do que acho que é o tema do nosso próximo painel, que são as ações de reparação de danos em cartel, né? A gente está falando de vara especializada federal aqui, e a gente sabe que as reparações estão mais no âmbito estadual, mas é muito possível que isso contamine a discussão no âmbito estadual de uma certa maneira também. Alguns pontos de destaque nessa discussão, nessa interação que a gente teve com o tribunal, é que ali se discute, na verdade, a especialização de varas e não a criação de varas. Isso tem uma grande diferença em termos de orçamento, que era muito importante para o tribunal, e da mesma forma que se discute ali a especialização de varas, não só sob o ponto de vista concorrencial, mas também comércio internacional. Então, são os dois pontos aí que estão mais fortes aí na agenda do tribunal, né? E seriam varas não exclusivas, o que significa dizer que essas varas elas continuariam ali com as suas funções, mas elas teriam também esse viés de especialização com relação a essas duas matérias. Isso pode soar um pouco estranho, mas eu acho que uma grande dúvida ali do tribunal é qual a real demanda que essas varas teriam se elas fossem exclusivas do ponto de vista concorrencial e de comércio internacional. Então, como um primeiro passo, parece que é uma proposta bem interessante. O tema da captura e da influência por grupos é sempre a primeira pergunta que vem em toda a discussão de vara especializada, e eu acho que o senhor trouxe aqui boas modelagens de como deve ser essas cortes, né? Aqui nós dizemos que são varas, nós estamos falando de criação de vara em primeira instância, e aí você também tem um segundo debate, que é, bom, você tem a especialização da vara, e como é que fica depois a decisão em segunda instância, né? Então, é desejável que se tenha algum nível de especialização nos tribunais superiores também, e eu acho que um ponto também de grande preocupação para nós sabemos que existem outras regiões, outros tribunais que também estão discutindo a matéria, mas até onde a gente sabe, eles também não estão se conversando para criar uma harmonização na implementação dessas varas especializadas. Então, isso traz uma certa preocupação de qual a modelagem que vai surgir. Nós temos aqui 5 regiões diferentes, né? Qual a modelagem que vai surgir em todos esses aspectos aí. Acho que esse é um desafio. Então, eu vou fazer uma pergunta que é mais geral, e para dar até espaço para o pessoal também fazer suas perguntas, mas como é que nós, advogados da prática privada, e as autoridades podem e devem contribuir nessa discussão de formação de vara especializada, tanto no seu aspecto criação dessas varas ou especialização dessas varas, quanto depois, após a criação delas. Qual que é o nosso papel vamos dizer, nesse debate com o Poder Judiciário?
Bom, só complementando o Bruno, muito obrigada, em primeiro lugar, pela sua presença, que nos honra muito aqui. Só para a gente, em benefício do tempo, tem alguma pergunta? A gente queria colher uma pergunta, talvez. Se alguém tiver uma... Não? Então, tá. Então podemos seguir. Obrigada.
Okay. Well, let me say something about the budget, the cost of this adventure. It needn't cost anything, really. Take the example of informal specialization at the first instance level, where it's decided that one, or if needed, more than one judge will hear these cases. And then if there's, at the second instance, if it can do this across judicial districts, I'm not sure how this works here, it would be a matter of assigning a panel, let's say, of 3 judges to hear these cases for a period of a few years, several years. And other than perhaps having a clerk of court to receive filings, and I'm not sure whether that would even have to be an incremental cost if it couldn't be done by existing staff, the cost should be very modest indeed. When we talk about creating a court, you think about building a building, but that's not at all at issue. As for, I mean, I don't know how you all interact with the judicial branch here. I would think, from what you said, that the judges are very open to hearing from the bar, and it seems appropriate. It's certainly the way things work in the U.S. as well. There's a good deal of back and forth. Nothing really gets decided in terms of administrative matters or reorganization without seeking comment from the bar or indeed from the public. So I think you must have a good relationship already. It's true.
Se não tiver mais nenhuma pergunta, e acho que não tem, então nós vamos ter o nosso coffee break. E logo depois o nosso último painel do dia sobre também esse tema de judiciário e as ações privadas de reparação de dano. Então, obrigado.